A thread by Joe Neerman. For any laypersons out there, today's concurrence from Justice Gorsuch attacks the Roberts decision in South Bay from 6 months ago as being, quote, Cocoa Puffs nuts. I have never seen a Chief Justice slammed by his peer like this. As Ron Coleman said, unprecedented times. I will do my best to translate certain harsher sections of the Gorsuch concurrence from lawyerese into two guys in a bar English. Quote, so we're going to take the first thing that's highlighted here. This is the legalese. What could justify, this is from Gorsuch, what could justify so radical a departure from the First Amendment's terms and long settled rules about its application? Translation. Before Amy Coney Barrett got here, we had a majority of justices who thought the First Amendment was a toy they could discard when they felt woke to do so. Next quote from Gorsuch. To justify its result, the concurrence reached back 100 years in the US. Reports to grab hold of our decision in Jacobson versus Massachusetts, 197 U.S. 11, 1905. But Jacobson hardly supports cutting the Constitution loose during a pandemic. That decision involved an entirely different mode of analysis, an entirely different right, and an entirely different kind of restriction. Joe Neerman's translation. Quote, but this is the SCOTUS. Even when the leftists run the place, they kind of feel obligated to try justifying the new rule du jour. So Roberts found this case Jacobson from 1905, pretended he totally misunderstood what it actually meant, and pretended it supported his wokeness. New quote from Gorsuch. Rational basis review is that the test this court normally applies to 14th Amendment challenges, so long as they do not involve suspect classifications based on race or some other ground or a claim of fundamental right. Put differently, Jacobson didn't seek to depart from normal legal rules during a pandemic, and it supplies no precedent for doing so. Instead, Jacobson applied what would become the traditional legal test associated with the right at issue, exactly what the court does today. Here, that means strict scrutiny. Joe's translation. This went poorly. Roberts had to stand on his head and read Jacobson backwards to reach his asinine predetermined conclusion. Ironically, Jacobson means the opposite of what Roberts said, so we will use Jacobson correctly in this case. Hopefully, Roberts learned something. Back to Gorsuch. Even if judges may impose emergency restrictions on rights that some of them have found hiding in the Constitution's penumbras, it does not follow that the same fate should befall the textually explicit right to religious exercise. Joe's translation. For decades, the left abused the Constitution to create transparently bogus fundamental rights. Them days are over. RIP, RBG. If you want to use COVID to ditch off some of your fake basic rights, have at it. You ain't messing with legitimate fundamental rights. I heart Amy Coney Barrett. Back to Gorsuch. Here, by contrast, the state has effectively sought to ban all traditional forms of worship in affected quote-unquote zones whenever the governor decrees and for as long as he chooses. Joe translates. Some of you lefty governors think you are God. Newsflash, you ain't. Back to Gorsuch. Nothing in Jacobson purported to address, let alone approve, such serious and long lasting intrusions into settled constitutional rights. In fact, Jacobson explained that the challenged law survived only because it did not, quote, contravene the Constitution of the United States or, quote, infringe any right granted or secured by that instrument. Joe translates. I should probably point to the part of the Jacobson decision that chillingly foretold that one day we may have a clown Chief Justice who would try to read their decision backwards and hauntingly said, "Don't do that." So I will quote that part to Roberts now, before I forget. Back to Gorsuch. Tellingly, no justice now disputes any of these points, nor does any justice seek to explain why anything other than our usual constitutional standards should apply during the current pandemic. Joe translates. The dissenting justices all know they were wrong. They're all pointing fingers at each other instead of trying to defend their idiocy from 6 months ago. They're devising an empty reason to dissent today because they're sore losers. But the word Jacobson chafes horribly. Back to Gorsuch. In fact, today the author of the South Bay Concurrence even downplays the relevance of Jacobson for cases like the one before us. Post at 2. Opinion of Roberts, C.J. All this is surely a welcome development, but it would require serious rewriting of history to suggest, as the Chief Justice does, that the South Bay Concurrence never really relied in significant measure on Jacobson. Joe translates. Oh, great. Now Roberts is pretending he didn't come up with Jacobson, like we didn't mockingly rename him Chief Justice Strebor, which is Roberts backwards, because he was so determined to read everything backwards. I was here, Strebor. I know what you did. You can't get away from Jacobson Gate. Oh, okay. Well, I think that's the end of the thread. So here we go.
I will be the greatest president that God ever created.